And good afternoon, everybody. It is December 1st, and we are here today to talk about LGAL and GAL issues. And I have a panel of very experienced and knowledgeable folks on this topic. So I wanted to introduce you to the panel first. And I want to remind everybody that we are recording this. And I know there's some people that have signed up and aren't able to come because they had to go to court last minute. So they will be able to watch it after the fact. And there's a way of chatting. And there's also a place for Q&A. I don't really care which one you use. I will do my best to monitor it during the session so that Keela, Scott, and Laura don't have to worry about that. They can focus on what they're talking about. So today we have with us three distinguished guests. The first is Laura Eisenberg. She is a partner at the firm of Eisenberg and Stillman, and she's obviously a dedicated family law attorney and a fellow of the American Academy of Matrimonial Lawyers. And she's also has served in the capacity not only as a legal guardian ad litem, but also as an expert witness on LGAL issues, which I think is really interesting. Scott Bassett, if you don't know Scott, you've probably been living under a rock for the past 20 years. Scott Bassett is a family law appellate practitioner. He works out of his home in Florida, but he comes to Michigan sometimes to visit us and go to conferences and sometimes even to oral arguments. So we always welcome Scott when he comes here. And I did want to note that a month or two ago, Scott received the Appellate Practice Section's Lifetime Achievement Award. And that is such a tremendous honor. Most of the people who have received it were either dead or judges. And I think there's been very few people who weren't in one of those two categories. So I think it was a tremendous accomplishment. And I wanted to make sure we acknowledge Scott's contributions to family law appeals. And then we have Keela Johnson, who is a shareholder at Geomarco Mullins. And I learned something new about Keela. And if you've told me this previously, Keela, I apologize, but I learned that you were a mental health therapist for 7 years, which I thought was fascinating. Keela has also, obviously she's a family law practitioner as well, but she has served as a GAL. So we have a bunch of different perspectives to bring to the table on these LGAL and GAL issues. And so we're going to start off the conversation talking about what this business is with LGALs and GALs, what's the difference between them, and who's serving as these people. So Laura or Keela, if you can take it away.
Well, I think that, you know, the difference between an LGAL and a GAL, although I think oftentimes judges, when they appoint them, often interchange the phrases and aren't really thoughtful about what they're really intending to do. So, you know, hopefully judges are being very intentional about what they're doing. An LGAL is really is really a lawyer for the child. They are advocating for that child. They are serving as their counsel. Attorney-client privilege applies. An LGAL doesn't testify as a witness. They are examining. They are the advocate for that child. A guardian ad litem is not their duty of loyalty is to the court. They serve the court. Both an LGAL and a GAL, their focus is, of course, the best interest of the child, but they have different, shall we say, clients technically. You know, I think that, so when you are the court is making a decision, or when the court asks you your opinion about what they need, you have to be thoughtful about what you're trying to accomplish. There are certain cases where it'll come, you know, it becomes very clear that a child needs representation. There are times when a child just needs representation. And that in those cases, an LGAL is the more appropriate fit. There are times where there's just more fact finding to do. There's more figuring out. The judge will say, there's a problem here, but we just need to figure out what the problem is. I think oftentimes as well, a GAL can be appointed for multiple children, and I think that's very appropriate. I don't personally believe that it is appropriate to appoint an LGAL for multiple children. I think that if you're going to appoint an LGAL, each child should have their own LGL. So I think those are, for me, some of the big differences and nuances between the two.
Keela?
I agree 100% with everything Laura said. As a GAL, it's more investigatory and you can talk to other people involved, grandparents, teachers, counselors, doctors, aunts, uncles, cousins, and you're the eyes and ears of the court, so to speak. Whereas when you're the LGAL, you're really focused on representing the child as the child's lawyer, like Laura said, and you're not doing as much investigation and seeking out all of those people in the investigatory manner to gather information to report to the court in that way, because your job is to represent the child, provide evidence, but do so as a lawyer, not as a reporter.
So
And what, oh, sorry, I just wanted to piggyback on what Keela just said. It's hard sometimes
It
because
is.
if you're an LGAL and if you believe what is best for a child is different than what the child believes, as an LGAL, you still need to advocate for what the child wants and what they want as their LGL. If you have a difference of opinion as the GAL, you can express the child's wishes if you feel it's appropriate to do so, but you also get to express your own opinion. Basically, as an LGAL, you're really that child's lawyer. You don't have an opinion of your own. That is really a very simple way of thinking about it. One is you have an independent opinion and ideas. One is you're representing a client.
and there's a statute on point if the lawyer guardian ad litem's position differs from that of his or her client, the child. There's a statutory provision that I want to use the word require, but basically the attorney is supposed to inform the court that there's a difference of opinion, and the court then has the authority to appoint a different attorney who's neither a GAL or an LGAL to represent the child in that very narrow situation of there being a difference in opinion on what's best for the child. Keela or Laura, lawyer guardian ad litem are very common in every single child welfare case, but they're not as common in family law cases. So can you either, any three of you really, share some thoughts about when we see a guardian ad litem or an LGAL in the context of a family law dispute?
Sure. Keela, if you want to go first.
Well, I can speak to the guardian ad litem piece because I don't get appointed as LGAL in most cases. I think I maybe have once, but in GAL cases, they're in the most high conflict of situations when parents are adversarial to each other, either pre-judgment or post-judgment, or in cases typically where there are abuse allegations, whether it's physical abuse, sexual abuse, substance abuse, alcohol abuse. Those are the cases I typically see come across my desk. I typically see a lot of physical and sexual abuse cases because of the background that I have in mental health counseling. I also tend to see a few cases, higher than a few, of autism cases or kids on the autism spectrum, because I've worked in that field in my past life, where parents have some issues with actually seeking out the needs, the resources that their children need. But those tend to be that the parents can't agree. They have legal custody issues where they can't agree on what their kids need, or the judge needs more information about what's actually going on with the children.
Keela, have you only served as a GAL in Oakland County cases, or have you seen them in other counties basically?
I've been appointed in Oakland, Macomb, Wayne, I believe Genesee as well.
Okay. And then Laura, since you have served as a lawyer guardian ad litem, can you address that aspect of it?
Yeah, and I think it's a fair statement to say that I think a guardian ad litem is used. It appears to me that a GAL is used more frequently in Oakland County than it is in some other counties. I've done it in Washtenaw County probably pretty frequently. Certain judges like to use a GAL, so I've done it in in Genesee. I've done it in Washtenaw. I've done it in Bay County. I think that sometimes lawyers recommend it to the judge, and then the judge kind of comes up with the concept. So your question again about the LGL, sorry, Lisa.
I think my question was what kind of cases you're seeing them
Sure.
have an LGL specifically.
Yeah. So I think that a judge once told me that the time when they most frequently, and it's really unfortunate, but the time where they feel they needed an LGAL is when they believe that unfortunately the lawyers in the case that they're working with do not have either the requisite experience or skill set to adequately represent what they believe the children's best interests are. And so sometimes if they think that a child needs to be more adequately represented, then they'll appoint an LGAL versus a GAL, because there's more limitations on really a GAL isn't representing it. I think that the other thing is that the cost of having a GAL is actually less than an LGL, because an LGL has to go to all proceedings. And really what it says is that a GAL is required at all court proceedings likely to affect the best interests of the child. But an LGAL is required at all proceedings affecting the child at all. So if I'm a GAL and there's a child support hearing, I don't go usually. I'll let the judge know, but I don't participate in that. If there's, little discovery issues or whatever, but anything affecting the child technically is an LGAL, you're supposed to attend. So the cost is much higher. So the other thing is, if judges feel as if a case is likely to go to trial, oftentimes will appoint an LGAL instead of a GAL, because then, like we were talking about earlier, technically a GAL is not supposed to cross-examine witnesses. They're not technically supposed to present the case, even though from a practical standpoint, the GAL, if you're doing your job, you know the case better than anybody because you've seen it from every side. You've spoke to the children, you've spoke to the therapist, you've spoke to everyone. So you know the case, but technically you're not supposed to present the case. So that's why sometimes judges will say, okay, I want an LGAL instead of a GAL. And sometimes sorry, Lisa,
it's okay.
Sometimes their child expresses a need for a lawyer. So the very first time I ever was an LGAL was when there was a 16-year-old child who actually technically wanted to emancipate herself during her parents' divorce, and she didn't technically fall within the statute to emancipate herself, but the judge felt that her interests needed to be represented. So that was the very first time that I was appointed an LGAL, was in that circumstance.
But Laura, how did that information come to the judge's attention?
Well, that information came to the judge's attention because basically the parent who was, shall we say, had a closer relationship with the child said, look, this is what my child wants. This is what my child believes. And it actually was very interesting. There was a difference of opinion as to who the child's psychiatrist was to be. So this child felt very, very strongly about continuing in with a psychiatrist and not attending a particular residential care program. One parent was absolutely adamantly opposed. One parent was like kind of on the fence, a little bit wishy-washy, and the judge was like, this child needs to be represented. And that's what happened.
That is very interesting. Before my next question, I got word that the chat function may not be working properly. So if you have a question, use the Q&A function. And I actually was hoping that I'd get some feedback from folks here in the audience that are coming from other counties and the ones that Keela and Laura have mentioned so far. If you're maybe up north or on the west side of the state, if you're aware of judges appointing LGALs or GALs in cases in other parts of the state, please feel free to use the Q&A function. So I wanted to just really briefly have Keela and Laura address how they get paid In those cases for Keela, the guardian ad litem, and for Laura as lawyer guardian ad litem?
Or how we don't get paid.
Thank you. I mean, tell me how it works.
Yeah, well, we started, I think Keela and I probably had a conversation about this and started a little bit of a different model. So up until recently, we never took retainers as guardian ad litems because it just felt, like that's not what you're supposed to do. So we didn't. And then what happened was you often don't get paid it's just the reality is you often don't get paid. And so the order appointing you will say what your hourly rate is. It will say how your hourly rate is going to get paid, but that doesn't necessarily mean that you're going to get paid. Unfortunately, judges are very reticent to order people to pay, and it becomes, and sometimes you get committed to these children. So now my practice is I take a retainer, not a huge retainer, but at least something, because these cases are just, I know for me, it's a 24/7 job. So when I'm appointed as a guardian ad litem, the child has my cell phone number, and they know that they can contact me 24/7, and they often do contact me 24/7. And so you're accepting a very, very time consuming, consuming job. So that's what I do. Keela, I believe you take a retainer as well. Yes.
I do, yes. I get the order of appointment from the judge that basically says Keela Johnson's appointed as GAL, and separate order of appointment will enter. And then I have my standard order of appointment that breaks down, if it's going to be shared equally, and that how the retainer will be paid, and how the payments will be divided. And then my standard provisions.
Keela, I actually wanted, now that you brought that up, that was my next question, actually, because I know that you have crafted an order of appointment for when you are being brought on as a GAL. And
Yes.
If you wouldn't mind just kind of describing some of the provisions that you include in that order for your GAL appointment, I think it would be really helpful for attorneys to realize that they could actually present an order to the court that really outlines what their role is going to be in a little bit more explicit fashion.
Absolutely. So it's actually been added to significantly over the years. Well, because as something happens, we add to it. It is, it's got the standard provisions of the quasi judicial immunity, and it has provisions regarding receiving past and future pleadings about issues regarding the children. It also specifies that there's no attorney-client privilege that is created by this relationship, whether it's with the parents or the child. And then I also have provisions regarding bankruptcy that I don't know if it actually will hold up, but according to a bankruptcy attorney that I consulted with, he crafted the language for me, that it creates a domestic support obligation, because I've had that happen, as I'm sure Laura has as well.
Many times.
And then reallocation of costs, which some judges strike if somebody misuses my services. I also have had somebody recording conversations without my knowledge and then playing them in court. So I have a provision that says if you choose to record them, you need to let me know. As well as sending the child into meetings with a recorder without telling me. So that's also in there because obvious reasons.
Happened to me.
Yes, that actually came from Laura's case. And I also have an end date on my appointment, because the perpetual appointment I have a problem with.
Well, how do you pick the end date?
I do 1 year. And then at the end of 1 year, they can either agree to reappoint me for another whether it's 6 months or 1 year or whatever. Or if they need to continue me, then they can file a motion if they don't agree. And that also I borrowed from Laura because of her parenting coordinator order. She had that in her order as well. So we borrow language from each other all the time.
And what I did, I created, and I had this, it was in my materials when I presented at this one time at the Academy. I have a checklist that I have for drafting an LGL order and a GAL order. I'm happy to share it with you, Lisa, and you can put it on your website or whatever. So we do a checklist. One of the things that I think Keela and I have talked about in the past is whether or not you require a written report. I personally put in my orders that I will report orally unless I am, the court orders me to write a written report, and I'll tell you why. The cost of a written report is so, it takes so many hours to write a written report. And we are not inexpensive. It's an additional lawyer working on a case. Ultimately, is it worth its weight in gold? It absolutely is, because and the statutes specifically say that an LGAL and a GAL should attempt to resolve the case. So in the statutes, it says that's the objective, to try to bring resolution of the case. But and most of the time we bring resolution to cases, but it's not inexpensive. So I try to avoid that expense, because if you're going to do a report, you got to do it right. I mean, it can take 10, 12, 20 hours to write a good report. It's very expensive. So I try to say we can do them orally and avoid that cost.
Before we switch topics, I wanted to share, Elizabeth McCree put in the Q&A that she's done both LGAL and GAL, or is aware of it, for Cass County and Berrien County, so down in the southwest part of the state. And the interesting thing is Cass County has a grant that helps fund the appointment of both the GAL and the LGAL, and they only use attorneys for that function. So I thought that was a really interesting piece of information for our Southwest folks.
I think there might be funds available in multiple counties for that. I think Judge Feeney mentioned that to me, that there are funds available for that.
So switching, go ahead.
Oakland County also has funds available. They're very reserved, they're very limited, and they're very protected.
Yeah, I can add a little bit to that. The enabling statute for the appointment of an LGAL under the Child Custody Act 722.24 does make specific reference to the marriage license fees. And, the state's allowed, each county's allowed to charge $20, I believe, for a marriage license fee. And 15 of that 20 goes to the circuit court counseling fund. And while that's often used for marriage counseling, it can also be used to pay for guardian ad litem fees. So that money is there. If it doesn't get used, it goes back to the county general fund. So
Right.
If courts have it, they should use it.
I've had one case that used those funds. So switching gears to
Lisa, one last thing before we switch. I hate to do this to you. I do want to also make everyone aware that if you have a case that you feel that a GAL is needed and there isn't funds for that, there are times, and I have relationships with certain judges, probably shouldn't publicize this, but we will do them pro bono. So there are times where judges will call me and they'll say, look, Laura, I really need a GAL in this case, but the parties don't have the funds. Would you be willing to do it pro bono, or would you be willing to do it for a reduced fee, or would you be willing to do that? And many of us who do this work, because you don't do this work to become rich. So many of us will do it for pro bono or on a reduced fee. So, the lawyers should, look and speak to the judges about that if it really
speak to the judges. Don't use Laura's name.
I agree with Laura 100%.
If they're going to call her, they'll call her anyway. So, okay. So we have a really hot topic to turn to, because, and this is probably what sparked my interest in LGALs and GAL issues. And I know Scott has done a bunch of appeals on this issue as well, is the confusion that arises. And I think it was Laura that mentioned at the beginning about how a person's appointed, but it's not really clear what they're being appointed as. Scott and I have also seen situations where a person's appointed as one thing, but then somewhere along the way is changed, converted to something else. And so I'm gonna let Scott take the lead on addressing his thoughts about that. But by starting off with what happens when, well, should the attorney's role change from LGAL to GAL or vice versa? And if it does, what's the consequence?
Well, it's a basic rule of legal ethics that no lawyer can serve two masters. And that's really the problem with cases where someone has been appointed, an attorney in most cases, as a GAL and then is later assigned LGAL responsibilities, or the other way around. And sometimes it happens on the eve of trial. Sometimes it's based upon, at least from my perspective, what the judge was hoping to accomplish in the custody trial, and thought that having one role might be more advantageous than the other. But I simply think that it's improper, probably unethical, for any lawyer to perform duties as a GAL and then switch and perform duties as an LGAL, or the other way around, because we can't serve two masters. I mean, you think about the implications. So if you're an LGAL, you're actually an attorney for a party participating fully in the litigation. I mean, children aren't technically parties to the case, but you're there, with the ability to examine, cross-examine, issue subpoenas, those sorts of things. So under those circumstances, ideally, you would not be able to speak with the parents without the parents' attorney present, because as lawyers, we cannot talk to a represented party. But what if you started off that case as a GAL, a regular GAL, and in that case, you're basically representing the court in a fact-finding mission to provide best interest information to the court. And under those circumstances, you may very well have spoken with the parents without their attorneys present. And how can you possibly then change roles? And you're not going to be able to segregate in your brain what you may have learned from those parents as a GAL, and then as an LGAL, converted on the eve of trial, able to cross-examine those parents based upon things they may have told you when you were performing a different role. I just think the two roles are, although the general goal is the child's best interests, the two roles are, in my mind, mutually exclusive. And, we've had cases, Lisa and I both had cases, not where we've both been on the same case, but separately, where we've had that issue of that role changing at some point during the case. And it creates all kinds of confusion and
Wreaks havoc.
And although it hasn't always been recognized by the Court of Appeals as error, it should have been. So I think that's a serious problem. I mean, we need to be very clear going into these cases what the role of this person is. I mean, when you ask for appointment of a guardian ad litem, make sure you know whether you're asking for a GAL or an LGAL and why you're doing that. And judges need to know the same thing. If they're appointing somebody, what are they appointing them for? Is this person going to be a lawyer representing the child as an LGAL, or a fact finder basically for the court as a GAL? They need to keep that mission in mind, and it can't change. I mean, if you think somebody should have been appointed as an LGAL, but you mistakenly made them a GAL in the beginning, I think the only choice then is they're off the case altogether, and you have to appoint somebody new, because I just don't think the two roles can be reconciled.
So we have two problems. One where the person is converted from one role to another midstream, but the other problem is when it's completely unclear because the terms are being used interchangeably. So Lisa Schmidt just asked in the Q&A whether how responsive are trial judges to a motion to clarify the role. I don't know the answer to that, but I would suspect that a judge would be happy to clarify. I don't know, Laura?
They are. A good GAL. So, a good experienced GAL is going to have a very thorough GAL order. And so most judges who appoint GALs are familiar with it. So absolutely. But if it happens, judges will absolutely correct it. And that's why the order is just vital. And I can tell you that I often go back to my order and make sure that I am complying with the scope and the order of appointment. It's very important to me that I do not exceed my authority. And so people will, they have an objection about something, let's say it's medication or something. I look at the order first to make sure that it's within the scope of my appointment before I even start talking about something like that. And I know Keela does the same thing.
I absolutely do, especially when it's coming to the issues of like custody or parenting time, because custody sometimes isn't included, or it'll say counseling or selecting a counselor, but it won't be parenting time. Or I can address parenting time, but it can't go beyond the scope of equal parenting time. I can't change the established custodial environment, or I can't recommend to change something that would change the established custodial environment. Sometimes it's very specific. So I have to be very careful.
The order
I think
is
especially as a GAL, an ordinary GAL, not an LGAL, it's important to have as much of that defined as possible, because, the Child Custody Act does define, at least to some extent, what an LGAL's role is, and then also references the juvenile code as well, as to, what the duties are, but we really don't have a firm statutory definition of a regular GAL. So that really needs to be in the order, specifying what the obligations are and the role and the duties.
I mean, frankly, we have that conversation all the time. What's the difference between a GAL and a parenting time coordinator? We talk about that frequently, but that's an entirely different show.
Yes.
So related to Scott's comment about, the ethical implications of wearing two hats at the same time or at different times of the same proceeding, Tracy Rink asked a question about a mediator who had served in the case as either a GAL or an LGAL. Is there an ethical conflict by acting as a mediator? What do you think?
I personally, my personal opinion is that I don't think that a person who has been a mediator and not an arbitrator, it's different. So if somebody is just strictly mediated a case and the parties have come to the conclusion that they need a guardian ad litem, I think that appointing a guardian ad litem, and they specifically agree at the time of the mediation what the guardian ad litem is doing, I don't think there's an ethical problem with it. I think it's a valuable tool. The parties have agreed. They've both spoken. The GAL has not spoken to the child. You know what I mean? And so I personally think that I don't have any ethical problems with that.
And the GAL has some familiarity with the case as well.
Exactly.
So,
I think it's actually a model that I find works very well, frankly.
But is your answer different if the person is going to be an LGAL?
My
Yeah.
answer would be different.
Totally.
So, yeah,
Absolutely.
right.
Totally. I
I
don't
think our
think you
instincts-
can. I don't think you can. You've spoken to the parties, both sides. I agree, Scott.
I also think, and it's not directly on point here, but I am troubled by mediators sometimes then taking on roles as arbitrators later in the case too. I do think that's improper because it's a very different role. If you're going from mediator to GAL, it's different than going from mediator to arbitrator or from mediator to LGAL.
Yeah,
Right.
I think Scott and Keela and I may have three different opinions about that, but it is a different, that also is
different role.
podcast,
Yeah.
right? Different.
I don't
different
have a
webinar.
problem with mediator to GAL because it's no different than when you're the GAL, you're theoretically a mediator of the situation, and you're short circuiting a lot of the information you're going to gather anyway.
Right.
From a
Because
financial and pragmatic standpoint, it really is a good model to do it. If the mediator is qualified, if you have a mediator who
That's
isn't
not qualified.
experienced, right? This is not, being a GAL is a very, very hard job to do. And it takes a lot of time
Mhm.
to learn how to do it. So, if you're not experienced and you just appoint someone just, what if, then you can really have some problems. That's why if someone's thinking about trying to start GAL work, my best advice to them is obviously educate yourself, go to the seminars, talk to someone who is a GAL and see if they're willing to do it. But if you're going to do it, start with a single issue appointment. Okay, so it's whether or not the child should attend this summer camp this year, or I mean, like really start simple. And, I know that it's not frequent that you get very singular issues, but that's the way to start off if you can.
Oh, and we all know that there have been GALs and LGLs appointed who were not qualified to do the work because they simply hadn't been around long enough or they didn't devote enough time to the case. And I sometimes wonder if we should have something in the court rules or something in a statute that provides some minimum standard or level of experience or training for a GAL or LGAL appointment, because we've all been burned by situations where, a judge for maybe well-meaning, maybe not, is appointed, the son or daughter of somebody that they, are close to, is brand new, fresh out of law school as a GAL in a case. And that usually doesn't work out too well.
It does. I mean, the statutes talk about the training, but it doesn't exist. I mean, that's the problem, is it needs to be formulated. And we were talking about the same thing with the parenting time coordination training. It just never got created, and it needs to.
I think there's LGAL training offered by the state of Michigan specifically for child welfare cases. So
Yes.
the family law attorneys are
Yes.
not even going to hear about those.
Yes,
trainings.
that's
It's
right.
not, going to be on the radar.
That's right.
And Tracy also asked about resources for learning more about it. And I think actually Keela and I are working on a project right now with the family law section for the State Bar of Michigan. Many years ago, I think it was Connie Thacker and Donna Mabili. I'm sorry, I'm looking over at my binder right now. Put together a book. I have the printed out copy, but it was in book form, Guardian Ad Litem Handbook.
Yep.
And Keela and I, with a group of other attorneys from the family law section, are working on refashioning it because it's really outdated at this point, and also it only covered GALs, and we wanted to cover LGALs and GALs. I think this is from like 2005 or something, from
It is.
really long time ago.
And
It's interesting, Lisa, you mentioned the family law attorneys may never hear about training designed for lawyers in the child welfare area. We probably do need more open communication between, say, the family law section and the children's law section, because every child welfare case has GALs. So just in terms of numbers, there are far more people with GAL experience in the children's law section than there would be in the family law section.
Yeah.
there's
good point.
another book that actually the person who taught me a lot about being a GAL was Janice Morgenroth, and Janice also wrote a book about, or a binder about family, about being a guardian ad litem. If you don't have, I'm going to try to see if I can find a copy of that.
I don't have that one.
Yeah,
I don't either.
she was amazing. She was amazing.
So we have a lot more to talk about, but I know a good question came up in the chat, and I know we were intending to address it. I don't think it's been addressed yet, about the confidentiality of communications. And I know there's a different answer depending on whether you're a GAL or LGL. So anybody that wants to lob out an answer regarding that topic, feel free.
Anybody, Scott, Scott, if you want to address it, it's pretty clear what the answer.
Well, yeah, because the LGAL is an attorney in the case, and their communications with their client, the child or children, if they represent more than one, and we already know the problems of possibly representing more than one child in a family, because not all children have the same interests. In fact, we should know that because, best interest findings need to be made individually as to each child. So we certainly should know that having a single LGAL for every child in the family is problematic. So we certainly know that under those circumstances, those conversations are confidential. Those are privileged. Now, if you're talking about an ordinary GAL, they can talk to anybody, and nothing that's told them is going to be privileged. And that's, the intent would be, and the expectation would be that information would go into a report to the court or be part of the GAL's testimony, since a GAL, unlike an LGAL, can and often is expected to testify in court.
An interesting question is whether or not a GAL can be in an in-camera interview with the child versus an LGAL. So that That topic has been addressed by the Court of Appeals, and it's
Really?
very, very interesting. So,
Remember what happened?
yeah, so an LGAL can be present because they are, so that the Court of Appeals case that I'm thinking of, and Scott, you probably know it, I could probably dig it out. That case, the Court of Appeals said there's no doubt, absolutely, because there's privilege that the LGL can be present during the interview. Hold on, I think I have that case. I actually think that it was a case involving, I think it's called Vanderbilt. Let me look for it, Lisa. I know I have it.
Well, what we're going to do, Laura, don't fret if you can't find it right this second, because sometime after today, probably next week, we'll send out a quick little summary of what happened with the statutory sites, because I know we're lobbing a lot of information out to everybody. I want people to have the names of the books and citations that we're mentioning, and I definitely want to include that case because I was not aware of whatever case you're talking about. And while you're looking for that, the next question has to do, continuing on this idea that there's a lot of confusion. Scott, you and I have talked about the liability issues with respect to being a GAL or LGAL. And could you address that and how that contributes to the confusion?
Right. Well, for a long time, it was assumed that GALs by court appointment had immunity from liability for potential malpractice or failure to do their duty. And there is a statute that specifically speaks to that later codified what had been the prior case law. But then we had this new thing created called the LGAL, and that was created after that statute was passed and doesn't specifically mention LGALs. But we do have a Court of Appeals decision, the case you were involved in, Lisa, that talked about extending that liability, that immunity from liability to LGALs. And I thought it was interesting because the logic of the Court of Appeals, at least the majority, was a 2-to-1 decision. The logic of the majority was that an LGAL is a subset of GAL. And that was how they folded that immunity theory into protection for LGALs. And I have to admit that I'm still scratching my head on that one because I don't agree. I mean, I don't see how an LGAL.
I agree with you, Scott.
Yeah, right. I don't see how an LGAL is a subset of an LGAL. They serve different masters. And although both are focused on best interests, they come about it from an entirely different way. So I don't see it. Now, it's not that I don't think that there should be immunity. There probably should be. But that's a separate statutory issue, I think, that the legislature needs to address. And I think it was a stretch to basically pull LGAL immunity out of the GAL immunity statute.
I can tell you, if you don't give an LGAL or a GAL immunity, nobody's going to do the job because someone is always unhappy with you. So, you take it on the chin and you get fake Google reviews that say all kinds of things about you, you know what I mean? That you have to, which you could, by the way, put in your order of appointment that no one shall put anything on social media regarding the children, the GAL or whatever, but people do it anyways. But, if you don't give people immunity, this is very hard work. You're not going to get people to do it because somebody always hates you.
Right. We saw the same thing with court-appointed psychologists doing custody evaluations. And that was a concern for psychologists doing those evaluations until we finally had case law making it clear that if they were court-appointed, they had quasi-judicial immunity.
One topic I wanted to make sure we addressed was the issue of the amount of authority that a court can give to a GAL who is, there to make a recommendation to the court. And I specifically was asking with respect to non-attorney GALs, but I think with some of our conversations earlier this week, it may not matter. But when the GAL is given authority, for example, to make a recommendation on custody and parenting time, that becomes an order of the court unless otherwise objected to. For example, so is there some limitations that should be placed, or are there limitations on what the court can give the GAL as far as its authority?
Well, I think it's perfectly clear. And I think Scott, you might have been, I think we were on a committee together one time about in drafting the PTC statute. So if it's not a non-lawyer, GAL cannot even for 1 minute cannot make binding decisions. They can't because they just can't under the law. So people make that mistake all the time. So a non-lawyer cannot have a binding decision at all. That's pretty clear. I think that there definitely should be limitations. I personally, if you want to appoint an arbitrator, just appoint an arbitrator. So, I think that they're very different roles. So I think that people do need relief. If, I get a call on a Sunday that, there's an emergency and you need relief, we're there to make a call very quickly. They're fighting about whatever, if it's going to the emergency or it's, stuff like that. We have to be able to help families out. But I personally don't like the scope of it being too broad, for sure.
I know I have challenged an order that I called it an improper delegation of authority. Scott, have you had that issue on appeal?
I have had that issue on appeal, and what often happens is that there's an order for appointment that is not as clear as it could be and doesn't specify what the role and duties are of the GAL or the LGAL for that matter. And if some action was taken that's outside the scope of that, rather vague order, then I think there's a good argument that the authority of the GAL or the LGAL has been exceeded.
And I think for me, it's not just the order appointing the GAL, but what is the judge allowed to put in that order, as far as decision-making authority. Okay, so I think we wanted to talk a little bit about how to work with an LGAL and a GAL to have a success if you're the attorney representing the parent, right? If you're the attorney representing the parent, how to work with the GAL or LGAL to have the most likelihood of success in your case.
Well, when I'm initially appointed, I send out a letter to the parties, if they're unrepresented, or to the attorneys, that I have like a checklist of items, because there's nothing worse than getting to the point of, my recommendation's almost complete, or I've interviewed everyone, or at least I thought I've interviewed everyone, and then all of a sudden somebody says, oh, by the way, I have a case pending in such and such district court for domestic violence, or did you know about the PPO, or there's this guardianship. So, because I've had those happen way too many times. So now I have a list of questions or requests, like, is there any pending domestic or district court cases, personal protection orders, guardianships, like ancillary matters that could play a part. Any other pleadings, any other juvenile delinquency matters, and I have a whole laundry list of items that I ask for: past pleadings, judgment, current custody orders. And I asked
so your file is getting very big quickly.
Well, I asked for them electronically.
Yeah, still.
And I have them all and then I ask both parents for them, because that also helps me to see which parent might be more involved in certain areas, like medical records or school records. And then I see who gives them to me, because almost always I have one parent that gets them to me within like 24 hours and one parent that never provides them, or provides them in a week or 3 weeks, or after 3 or 4 reminders, or, sometimes I get them from both. Or I have one parent that says, have you received them from, the other parent, and what do you still need? And that often tells me my appointment's going to be very short-lived.
Yeah.
So
Keela and I do a little different model. I think my model may be a little bit old school. I use the Janice Morgan-Ruff model because she was my biggest mentor as a guardian ad litem. So Janice always said, start with a conversation. So I always start my appointment even before I draft my order, clarifying my duties, because that's what I call my order is order clarifying guardian ad litem duties, because the order's already been entered. So it's not really the order appointing me, it's my order clarifying me. So before I do that, I like to have a meeting with counsel. If I do it when there's counsel, and if there's no counsel, I will talk to the parties and just talk to them about what was the intent, what are we doing here, what is the order gonna, you know what I mean, what are we trying to accomplish, what are the problems involved. So I like to do that just because Janice taught me that you just get a really good feel of the case and what you need to do, and make suggestions with respect to what we shouldn't be doing in this case. And there have been times where I've had that meeting and I say to everybody, I don't know, guys, you really think you need a GAL? Maybe you do another mediation session, or maybe you go to a family therapist. Why don't you try a meeting with a family therapist first? And then if you feel that didn't accomplish your goal, then we'll take this next step. So I always like to start with that. And how can you be successful with a guardian ad litem? Being responsive to them. That's the most important thing, is to be responsive, and don't try to play the guardian ad litem. I think that that is the number one thing that experienced guardian ad litems, people who have done this for a long time, you're not going to convince us. You're not going to manipulate us into coming to a conclusion that favors your client. And we're smart enough to know when people are trying to manipulate us. So just have an honest conversation with us, but don't constantly try to maneuver and manipulate for your desired outcome. It's very, very transparent. I think there's so many very experienced lawyers who do it all the time. And it's shocking to me that they don't know that we know exactly what they're doing. Do it, participate in good faith, honestly, to try to resolve it and think about the best interest of the child. Not try to game us, so we're going to make a recommendation in your favor.
So go ahead, Scott.
One of the difficult decisions, I think, for an attorney representing one of the parents in a custody dispute is whether there's an LGAL. Do you let your client meet with the LGAL without you being present? I mean, I can just think of the potential for malpractice litigation, where if that parent loses custody and it's because, on cross-examination, the LGAL went after them on something that they told the LGAL in a private conversation when counsel wasn't present to stop them from saying, something stupid or damaging. I mean, you don't want to be a jerk about it and deprive the LGAL of information. On the other hand, do you want to let your client loose with somebody who is essentially an attorney in the case?
Well, and I'm going to tell you, that's exactly the case where I testified as an expert. A GAL was converted to an LGAL, and then the LGAL was holding it against one of the parents that they would not speak to them without counsel. And it was really, I think it's a no-brainer, but that a client should never speak to an LGAL without their counsel present. That to me is a no-brainer. But the case was just messed up all the way. But how the GAL, now LGL, is going to hold literally wrote in the report that this person was uncooperative. And, that is like a buzzword that is often used against parents. They're uncooperative. And so if they're not knowing what they're doing, you've got a problem to begin with, and you've got to somehow get to the judge for clarity before that opinion, before you're in trial, before anybody's writing a recommendation, to try to do some damage control on it.
So a comment that you made earlier, Laura, actually leads me to the last question for the day. And you were suggesting that maybe this family just needs a therapist or needs to go to mediation again. And so the last question of the day was, are there alternatives to using an LGAL or GAL that will maybe help reduce conflict without increasing the cost of the case? Keela, I know you had a couple of ideas.
Sometimes the whole issue that I've seen can be communication between the parties. One speaks and the other, one is speaking French and the other's hearing German, for example. They can't hear each other communicate. And sometimes our Family Wizard or an app that's similar to that can help them actually communicate more clearly with each other. Like Laura said, sometimes family counseling can help with that too. And that can help the parties communicate and actually hear what they have to say, instead of making it a huge conflict that runs up a bill of $10,000.
And sometimes pausing before you actually move forward and making a list of actually what the problem really is, not generically, but specifically. And if you really break it down to what the problem really is, oftentimes those issues can be narrowed. They can be discussed with the therapist. They can be discussed in mediation. You know, it's flushing things out, because the conflict overwhelms people. The emotion of being upset oftentimes, you know, just overwhelms it. And, you know, we, as GALs, we know when we've got work to do and when we think that we don't, if there's another methodology that might work.
Any other ideas to reduce conflict?
You got to start early. So you can't sit on a case. If there's conflict, there's issues with the kids, you've got to start communicating early. You've got to start, you know, and I think one of the things that I've been preaching about recently is, Lisa, we were together at the Academy seminar in Chicago, the national seminar. And one thing that shocked me was learning that conflict, any conflict that children are introduced to or are feeling, that creates irreversible damage to the children. I thought if we get in early and there's conflict, we can correct that it's not creating an irreversible scar on that child. But the research shows that it does. I was shocked by that, Lisa. I don't know.
Laura, I just got chills just remembering the video that we were shown.
Oh my
And
God,
I want to see if there's a way we can share that with people.
We're going to get it.
Not today, but
we're going to
get some other conference. Okay.
And
it
so,
was like amazing.
Amazing. So we've got to get there early. We've got to, so if you're a practitioner and you see that, you know what, these people are going to have a custody, they have different opinions, get them in early, get them into some really good family counselors. We've got to work on creating better resources for them, but the lawyers also need to start thinking, look, resolution is what we need. Litigation, you're going to be out of there. The litigation is going to damage these children forever. So we've got to be changing our mindset to exactly what they taught us at the seminar was, it needs to be child-centric. It's not about what the parents want or what they think is best for their child. It's what's legitimately best. So if we put that front and center first, it's going to help those kids.
Keela, could you quickly tell us about that Oakland County FOC program that you had mentioned to me the other day?
It's the COPE program. And Vicki Rupert is the one that organizes it. It's on the Oakland County Front of the Court website under the programs that they have. It's co-parenting effectively. It's a 3-hour program. Usually it takes a judicial referral or she has forms on the website. But I'm sure Vicki would be happy to talk to other counties about the program.
I was going to say, how can other counties get
Yep.
onto board with this program?
I'm sure Vicki would be happy to talk to other counties about the program itself. But it's amazing. And they working with the parents to learn how to co-parent together and do it effectively and decrease the amount of conflict that these kids are witnessing, even at parenting time exchanges. And, you know, once we get them separated, and I couldn't agree with you more, Laura, that we have to make this focused on the kids and not what is best for me, therefore it's best for the kids, but what's actually best for the kids.
Whatever you think is best for the kids, it's not more important than the child being in a conflict-free environment. That causes more trauma. That hurts a child more than anything else. And getting that through people's heads, especially right now, is very, very difficult. COPE is generally thought of as a program for parents who have problems. Frankly, in today's environment, really COPE needs to be, I think that before you get a GAL appointed, before you do certain things, they should be required to do COPE or something similar. There's a program out of Maricopa County in Arizona that is supposed to be a phenomenal program. It's not national yet. It's going to go national, and hopefully we're going to be able to bring that to Michigan. So I'm going to try to see if I can work on that. And Keela, maybe you can help, but we need
Love to.
more education, more, and I also think I don't mean to sound corny, but back in the day when we started the SMILE program, Richard Victor started the SMILE program, but when we did it, and Dr. Nancy Fishman, they brought me in very, very early on when I was a GAL working on a case with Richard, those in-person SMILE really were effective, and having multiple different people speaking to the hearts of these parents as they're sitting next to each other was very, very effective. And just touching people a little bit and giving them some time, I think it makes a difference.
Yeah, that was a great program. After a while, I used to alternate with Richard on the
Yes.
monthly meetings, and we would have, a family law attorney there. We'd have one of the family court judges, usually either Ed Sosnick or Joan Young, both retired now. And we had people from the front of the court, and we had mental health professionals. And it really helped to get that perspective in front of the parents who were at that point fairly early on in their divorce journey. And, hopefully before, they got too entrenched in the conflict, although sometimes people get entrenched very quickly.
So, and I know I have a book in my office that Richard Victor sent me several years ago. I'll make sure to hunt it down and include it in the list of information that I'll send out next week.
Yeah.
So Scott, Laura, Keela, I thank you so much. This was so engaging and helpful for everybody. And I really hope that the attorneys that are representing clients in the trial court, and maybe if any judges that can pass it along as well, can really use the information from today to reduce the conflict in cases and have clearer orders on whether there's a GAL or LGAL.
Thank you for having us, Lisa.
Yes, thank you, Lisa.
Thank you, Lisa.
I'm going to shut off the recorder.